Good afternoon, everyone. So we would like to do a bit of work as far as our revision towards this year's Ghana School of Law Entry examination is concerned. We are going to be discussing something in relation to criminal procedure as within Ghana legal system. And I will be doing that in the form of a panel discussion with some of my junior colleagues who have been invited to join. But just before we start discussion for the first session of today, we are just doing 1 hour, and then in the night, I will come your way with a landlord discussion. That will be a bit late in the night. Yeah, so before we start our criminal procedure or introduction to criminal procedure, it's a topic within Ghana legal system. Let me give 1 or 2 tips as far as revision strategy and preparation towards the exams is concerned. So first, people ask, so what should we learn? Let me reiterate that the best assurance of writing these exams and making it just once is that 6 subjects are going to be examined. Now, just be honest with yourself. First of all, I've said this before, take each of the subjects, list all the topics in each of the subjects. And when you have listed the topics in each of the subjects, take each topic under each subject one after the other and ask yourself, do you understand this topic? Or is there something about this topic that I am not sure? I made this suggestion some months ago. I'm going to reiterate it, that especially so when we have just 1 month to write the exams, do what we call a critical self-audit, right? Critical self-audit as far as your learning is concerned. And what do I mean by that? Just make time, get maybe 2 or 3 separate hours in 2 sessions to be able to do the critical self-audit for all the 6 subjects. So maybe you get 2 to 3 hours in a session. You target maybe 3 subjects, right? So you take 1 subject. You give yourself about, let's say you give yourself 1 hour. List all the topics in that subject. And when you have listed the topics, take the topics and you're on your own without opening any book, without Googling or anything on the internet, just on your own. That topic, summarize the key ideas, okay? Summarize the key ideas under that topic. When you are done with that topic, move on to the next topic. You summarize the key ideas, right? The key ideas here also include the key authorities that you remember. The key authorities that you remember under that particular topic. So you will repeat this for all the topics under that particular subject. And if you can work a bit fast, 60 minutes or worst case scenario, you give yourself maybe 90 minutes. You get that done for 1 subject. Then you move on, you take maybe 5 minutes or 10 minutes break. Then you move on to another subject. On your own, without opening any book, list all the topics under that subject. And then take each of the topics. And on your own, without opening any book, just summarize the key ideas under that topic, as well as the leading authorities under that topic. So once you do that, you move on to another subject. And as I said, in 2 separate sittings, maybe over 3 hours or thereabout, you should be able to get your audit done for each of the 6 examinable subjects. Now, that will give you a very honest assessment of where you are. And then at the end of that exercise, you'll be in a position to know which of the topics or which of the subjects you need to do a little bit more work. So once you have gone through that, you are left with only one thing, and I am sure that nothing will prevent you from being successful. And what is that thing? And what you'll be left with is to polish your question answering skills, right? And as you know, we are going to have 1 or 2 main types of questions: essay question and then a problem-based question. So just make sure that you keep trying your hands on how to properly write essay question and how to properly do problem-based question. So once you get that done, I'm sure you're very good to go. So having said that, we would like to come to a substantive discussion, and that is an overview of the criminal procedure in Ghana. If you have my Ghana legal system and legal method, you can supplement that discussion with chapter 5 of that, maybe as well as any chapter on any other book on the subject. So as I indicated, I have 4 colleagues who are going to join me to do this discussion. It's going to be a bit of like a panel discussion. So an overview of the criminal procedure in Ghana. So I would like to welcome my other panelists before we move on. David, can we see you? David, yes, I'm here. David, can we see you? Okay. So David is here, right? Can we see Belinda?
Sir, Doc, please, I'm here.
Okay. Ajua?
Doc, please, I'm here.
Okay. Okay, so I think we have I don't think I've exhausted my panel.
Doc, Loretta is also present.
Yes. Loretta, can we see you?
Doc, please, I'm here.
Okay, good. So, criminal procedure. First of all, when you talk about criminal procedure, let us remember the distinction we've drawn when we're discussing classification of law, that we have a crime and then we have a civil wrong. When we're discussing introduction to civil procedure, we understood what a civil wrong was. That is wrongs emanating from violation of the civil law, be it the contract torts or land law, employment law, and so on. These are all civil wrong. Those are not the things we are talking about now. We are discussing what we call crime, and also the procedural arrangements and various institutions associated with enforcement of criminal law. So therefore, a criminal procedure or criminal justice system is nothing more than the set of arrangements, rules, procedures, and institutions which are connected with enforcement of criminal law And as you know, according to Ghana's constitution, no one shall be punished for a criminal offense unless same has been defined in a written law with the prescribed punishment. So let us keep those things in mind. So anytime we hear of a crime, we remember that there's a particular enactment which has defined a certain conduct as amounting to crime. Once you have the requisite mens rea and then the actus reus. The actus reus being the prohibited act, and then the mens rea being the guilty mind, which is required for the commission of the crime. The only exception to the rule that for a crime to have been committed, you must have coincidence of actus reus and mens rea is when you are dealing with the strict liability offenses. So with respect to strict liability offenses, the emphasis is not so much on the mens rea, because the mens rea is considered to be embedded in the actus reus. So once the actus reus, the prohibited act, for example, has been indulged in, it's assumed that the offense has been committed, and you don't need to do any separate analysis as whether there's a mens rea, that is like the requisite guilty mind or not. So let us keep that in mind, ladies and gentlemen. So having said that, in terms of institutions which form part of the criminal procedure, we have like the police. Obviously, police are important. Without the police, difficult to effect arrest, although the constitution and for that matter, the common law, I should say, permits what they call the private citizens arrest. I know that that is quite associated with so many dangers. So the police, very important agency or institution when we are dealing with criminal procedure. So oftentimes you notice that they will receive complaints and then they will do the investigation, build the case docket, or assemble the evidence, which will be used by the prosecution or the prosecutor to actually prosecute the accused person. So the police is very important. And we also have the Attorney General, another very important institution. We know the Attorney General in Ghana refers to a person and an institution. A person in the sense that there's one person called Attorney General. An institution in the sense that it's not just the person, but that person is a whole institution. Okay, so if you look at Article 88 of the 1992 Constitution, it is quite clear that as far as criminal offenses are concerned, they shall be instituted by the Attorney General. So the Attorney General, if you look at 88.3, he has a responsibility for initiating and conduct of all prosecutions of criminal offenses. So let us keep that in mind. But that notwithstanding, the Attorney General would bring the criminal cases in the name of the Republic and not in his name. So if you look at it, when it comes to, let's say, civil cases where the state is a defendant or where the state is even a plaintiff, you will not say Republic of Ghana against someone or someone against Republic of Ghana. We rather say that Attorney General against someone or someone against Attorney General. So, but when it comes to the criminal cases, it's rather directly in the name of the Republic, despite the fact that the official behind it ultimately is the Attorney General. I must also say that quite apart from the Attorney General, some other institutions are also given the power to prosecute criminal cases. And you know this very well. For example, some police officers, and then some other institutions like the GRA, and then even like the SNET, where they have been given some prosecutorial powers. But that one is just delegation, because the Constitution contemplates that it is the Attorney General who is ordinarily responsible for all criminal prosecution in the country. So let us keep that in mind. Another important institution, as far as criminal procedure is concerned, is actually the what we call, maybe just before I leave the Attorney General, it is important to remember that the Attorney General has so much powers over criminal cases. And remember very well what we call the NP, or Nolle prosequi. Nolle prosequi, if you look at the section 54 of the Act 30, that is the Criminal Procedure Act. The Attorney General has the power at any stage of a criminal case, for example, to cause to be filed in the court or issued what we call Nolle prosequi. And the Nolle prosequi simply means that the Attorney General is saying that he is not interested in continuing with the prosecution of the case. And he doesn't have to give reasons, right? He doesn't have to give reasons for filing Nolle prosequi, as it were. It's just a declaration of intention on the part of the Attorney General not to continue with the criminal proceedings. And this can be issued at any stage of the criminal case, before a verdict or before judgment. Okay. Yeah, so let us keep that in mind. And of course, where Nolle prosequi has been filed or entered by the Attorney General in an ongoing criminal case, the accused person will be discharged immediately in respect of the charge for which the Nolle prosequi is entered. And then where the accused person, for example, had been committed to prison, either he was in remand or something like that, as soon as the Nolle prosequi is entered, the accused person will be released. And again, where the Nolle prosequi has been entered and the accused person, for example, had been admitted to bail, and then there were some other people who were the recognizance or the surety of the accused person, then the entry of the Nolle prosequi will mean that they are also supposed to be discharged. They are supposed to be released from the legal obligation that they face by signing up a bail for the accused person. But let us remember that the fact that Nolle prosequi has been entered does not mean that the accused person, for example, cannot be arrested, cannot be arrested again, because the Nolle prosequi means that you'll be discharged. Okay, you'll be discharged. Now, if you look at the Constitution, particularly if you look at Article 19 of the Constitution, there is a provision to the effect that no person shall be punished twice for the same offense. If you remember that, which you learned some time ago, that no person shall be punished twice for the same offense. And what we call the rule against double jeopardy. The rule against the double jeopardy, that is to say that where you have been actually been dealt with according to the the criminal procedure and all that, in respect of that same charge, in respect of that same facts and offense, you cannot be punished again. Otherwise, the criminal justice system, instead of being for prosecution, will have become for persecution. And no one is supposed to be persecuted by the state. Good. So where Nolle prosequi has been entered, you are discharged, all right, but that means that verdict has not been pronounced, judgment has not been entered. And for that matter, if you are arrested and then you are made to be prosecuted for the same offense, you cannot raise your constitutional constitutional right that a person shall not be tried twice on the same offense. That is very important. So if you look at the Article 19, clause 7, if I may quote, no person who shows that they have been tried by a competent court for a criminal offense and either convicted or acquitted shall again be tried for that offense or for any other criminal offense of which you could have been convicted at the trial for the offense, except on the order of a superior court in the court of appeal or review proceedings relating to conviction or acquittal. Yeah. So once you have been, tried, either convicted or acquitted, then you cannot be tried in respect of the same thing again. But again, as I said, that that does not apply to cases where a Nolle prosequi was found, because Nolle prosequi means that the person was actually not pronounced guilty or acquitted for being innocent. So let us keep that in mind. Another institution which you have to remember in talking about the institution related to criminal procedure, before we come to look at some aspects of it, is the court. Part of due process is that everyone is presumed to be what? Innocent, presumption of innocence, where it's alleged that you've committed an offense and all that, you are not guilty until you be proven guilty beyond reasonable doubt. And that can only take place before a court of competent jurisdiction. Before a court of competent jurisdiction. So maybe I'll ask my panelists, as far as the role of the courts are concerned in criminal procedure, criminal justice system, are there any other thing that we should also remember? Yes, any of my panelists may contribute.
Sir, so far, I think you've done a good job, sir. The point that I also want to make or put across is the fact of the jurisdictions of the court when it comes to offenses. Some offenses are supposed to start from the district court. Some can be sent straight away to the circuit court or high court. For indictable offenses, for instance, sometimes you are supposed to Sorry, sir.
Yes.
So what we are trying to say is that for indictable offenses, for instance, you are supposed to get committal from the district court before it is sent to the high court, and then the trial will then continue. This is it for now, sir.
All right. Thank you very much, David. My other panelists, is there anything, Loretta? Okay, then I think we'll continue. Yeah, so as far as the courts are concerned, as David indicated, jurisdiction is very important. So when it comes to criminal cases, we have, if you like, there are two main types of jurisdiction. what they call the summary jurisdiction, right? And then jurisdiction, which also relates to trial on indictments. So as indicated, for certain offenses, which are called indictable offenses, and one which is automatically indictable is murder. Of course, the Attorney General also reserves the power to choose to have any offense to be tried on indictment. And what does it mean to say that an offense is being tried on indictment? That is to say that you have to go through 2 stages, one in the district court and then one in the high court. The district court, what they call it, the committer stage or the committer proceedings. At that stage, the court will have to find out whether all the basic elements which are needed, the charge sheet, the summary of evidence constituting the bill of indictment in relation to the particular offense. Is everything present? Does it appear that they suggest prima facie, for example, that that offense has been committed in the sense that the requisite ingredients have supporting evidence according to the summary of evidence and then the charge sheet and all that. So that is what is done in the district court in relation to the committer proceedings. But quite apart from that, a lot of petty offenses, which are called like misdemeanor, they are tried in the district courts, and of course the high court has jurisdiction in all matters, as we know. The circuit court, of course, cannot usually do a trial on indictment. It's usually done in the high court and started in the district court. Yeah, so in terms of the institution, I think that let us keep this in mind. Again, we may also have to remember that when it comes to what we call, yes, I think somebody hand is up before we continue. Yes, yeah, the person whose hand is up, speak.
Yeah, my question is, I don't know if you can clarify this for me. Is it does the Attorney General really has discretion as to choosing which crime to prosecute on indictment and which to prosecute on summary, or it is prescribed, and once it's prescribed, the Attorney General does not have that jurisdiction to do so?
Oh, okay. All right, thank you. My panelists, will any of you have a bite before I come in?
Yeah, yes, sir.
Right.
What our brother just said, sometimes the law will prescribe the mode of trial. So where the court or where the law prescribes the mode of trial, that is what the prosecution and then the court will go by.
So when you look at section 2 of the Criminal and Other Offences Procedure Act, it talks about offenses that can be tried summarily, and also offenses that are tried on indictment or summarily. Yes, on indictment, and also any other offense is triable on indictment or summarily. So subsection 1 talks about the offenses that will be tried summarily. And it says that such offenses are offenses that the enactment provides that is punishable on summary conviction and does not provide for any other mode of trial. Or the enactment that created the offense makes not a provision for the mode of trial. And when you look at the maximum penalty for that offense on first conviction, it's a term of imprisonment not exceeding 6 months, whether with or without a fine. Then subsection 2 talks about offenses that are tried on indictment. And that is where the offense is punishable by death, or it is an offense declared by an enactment to be a first degree felony, or the enactment that creates the offense provides that the mode of trial is on indictment. Finally, subsection 3 then says that any other offense can be tried on indictment or summarily.
Okay, all right. I mean, that is fine. Thank you, Rajua and David and Loretta. Then we must also have regard to section 242, section 242 of the Act 30, that is Criminal Procedure Act. It gives the power to the Attorney General as the Minister of Justice, right? Because if we look at the section 242, subsection 1, it says, and I quote, the minister, so the minister here refers to the Attorney General or the Minister of Justice, may by legislative instrument appropriate an offense or class of offense to be tried with the jury. So the Attorney General has the power to either come out with an airline saying that the following offenses shall be tried with the jury. That is, it shall be tried on indictments. And again, if we look at subsection 4, that is section 242, subsection 4, it also gives the, if you like, the right to the accused person, okay? The accused person to request the court or the Attorney General that the particular offense for which is going to be tried should be tried with maybe assessors instead of maybe like with the jury. So the bottom line is that, as my panelist said, that those offenses which have been indicated as to be tried automatically by on indictment, and that usually involves with the jury, although that can also apply to assessors. And then there are some other offenses which are not so indicated, but depending upon the pleasure of the Attorney General, insofar as it will serve the ends of justice, it can be tried with the jury, and that is as a trial indictment. So let us keep that in mind. Now we would like to move on to quickly look at what they call how criminal procedure actually start, and that begins with complaints and lawful arrest. Yes, iPhone, your hand is up. What is it?
Yes, so to clarify, what you are saying is that it is not when the crime has been committed and then the Attorney General then decides that, okay, I'm going to trial this particular offense on indictment. However, he would have prescribed it, so it should have been law. Is that the case, or it is when the offense is committed and he can decide with his discretion that, okay, this one I'm going to, that is the clarity I really want.
Yeah, no, both cases are possible. The crime could have been committed, and based upon the section 242 that I read, if the Attorney General thinks that the ends of justice will be served, maybe the particular offense is said that we like the people through their jury to participate in establishing certain factual aspects as whether something happened and then it violates our law or not. He could, for example, elect that offense should be tried on indictment. And if the Attorney General chooses even to have an offense which has been committed to be tried on indictment, although that offense ordinarily is not an indictable offense, it is rather even for the benefit of the accused person, because trial and indictment affords a lot of protection to the accused person. We are expanding the scope of investigation of the alleged wrongdoing and so on and so forth. And you stand a better chance of actually being acquitted if there is really risk that you didn't commit the offense, maybe according to what other members of society through their jury look at it. So there's nothing wrong within the meaning of section 242 if an offense which is not ordinarily prescribed to be an indictable offense has been committed. But in the interest of justice, the Attorney General, for example, orders that it should be, it should go through the route of a trial and indictment. Yeah, that can be done. And that does not violate the Constitution or fundamental human rights. It rather advances it, in my view. I don't know if that assists you.
Yes, thank you. Thank you. That's quite.
Okay, thank you. Yeah, so how are criminal proceedings instituted in Ghana? Criminal cases, how did they start? Of course, they start by either you made a complaint with the police, or you made a complaint, let's say, to the district court. You have like a criminal summons issue. And let me say this: it's not all the time that the police will have to arrest someone before criminal cases will start. Criminal summons can be issued. And if you remember the famous Republic against Chachuchi Kata, when the current president was then the Attorney General of the land, if you look at that case, I think that it was started with the issue of criminal summons, which is permitted by the Criminal Procedure Code. Good. Or maybe a complaint might have been issued to the police, arrest effected, and then on that route, the case will come to court. But where an arrest is going to be effected, then you must always remember the constitutional protection which are afforded to a person who is being arrested. I think that, I don't know, that last year or a year before, an aspect of the examination required that. So you have to remember your human rights in relation to a person being arrested. Okay, so remember Article 14, among others, that when a person, the requirements of a lawful arrest is something that we know already, that you are told the reason for your arrest in a language that you understand. You're entitled to a lawyer of your choice. You are told of your right to what we call the right of innocence because of the presumption against self-incrimination and so on and so forth. So go to Article 14 of the Constitution and remind yourself of the various guarantees which are given to a person who is being arrested. Now, so let's assume that the arrest has been effected. Now, the person is either arraigned before court or not arraigned before court yet. The person is entitled to bail. The person is entitled to bail, and as you know that you cannot detain someone for more than 48 hours. So a bail simply means that you are granting the release from legal custody of a person by undertaking or guarantee that such a person will appear or be available at such place and time. So a bail is, if you like, is a sort of like a contract between the person who is being granted the bail and the state, or whoever is signing for that person, that on this day, at this time, at this place, when he's needed, he'll be there. And a sum of money is put on that bail. And the sum of money is not money to be paid. That is to say that if you should breach the bail bond or the bail terms, that you are going to be made to pay that money later on when the bail is treated, as it were. Yeah, so we have to remember the circumstances in which bail will be available in criminal cases. When the trial is pending, trial is not one day. It may be going on a number of days, weeks, or months. So the person being tried, accused person, may be admitted to bail. And then sometimes a person has been convicted, but he wants to appeal. maybe during the appeal, a pendency of the appeal, a bill may also be what may be granted. So let us remember these basic things, and of course, from your constitutional law, you remember Martin Pebbles' #2 case against the Attorney General, where the Supreme Court actually declared portions of Section 96 of Act 30 as being unconstitutional, especially so when it created the impression that certain offenses were not available. Now, the proper understanding of the law as a result of Supreme Court interpretation is that every offense is what is bailable. Every offense is bailable as it was. So let us keep that in mind. Is there anything on bail which my panelists would like to add before we move on?
Okay, Doc, please, what I want to add is that with bail, they are discretionary. So either it's bailable offenses, so the court has the sole discretion to grant it or not. That's what I can add about.
Also, when you look at Martin Pebble #4, the Supreme Court had to look at Article 14(3) and 4 as to the time that the person is supposed to be brought before the court. And the Supreme Court said that the law is that within 48 hours, anybody who has been arrested, detained, or restricted on the suspicion of committing an offense or for committing an offense is supposed to be brought before the court within 48 hours. And the court can then give an order to remand the person. And it is only on that remand that a person can be kept for more than 48 hours. If not, the person is supposed to be granted bail for the person to go.
Okay, thank you. Yes.
Yes. One point is that the bail conditions that the court might set for the accused person to meet. Normally, the sureties are supposed to, if the bail condition is so harsh that the sureties must deposit some documents of their property or something like that. If the accused person becomes bail, then the court or the AG, Attorney General, is going to excrete the bail bond against the sureties. Originally, the people were supposed to have been imprisoned, but the court held that now it is a civil matter, but not a criminal matter. This was held in Martin Pebble #1, that if you are supposed to excrete a bail bond, it should not be a criminal matter or contempt matter, but it should rather be a civil case against the surety.
Okay. All
Okay,
right.
Doc.
Yes.
Once that bail is not just granted by the courts, but then the police also have the power to also grant bail. So then it is within 48 hours. If the police have granted bail, that they can also go to the courts for bail application. Thank you.
All right. Thank you, my panelists. Thank you very much. Now, so we come to address mode of trial. So at this stage, the assumption is that investigations are completed, charges have been preferred, and the accused person is to be arraigned or put before the court. So as we have noted, we have two main modes of trial: summary trial and then trial on indictment. So we'll first talk about summary trial, which we have already hinted about in an attempt to answer question one of you asked earlier on. So we know that summary trial are held in all the courts, all the trial courts. If I say the trial courts, that is from the district court, circuit court, up to the high court. Of course, the Court of Appeal and Supreme Court, you don't do no summary trial there. The only exception is when someone is being tried for contempt of court. For that one, every superior court of judicature has inherent jurisdiction to summarily try anyone for cases of contempt of court. So that one is a very limited exception. So now let's come to ordinary summary trial. So the procedure is just pretty straightforward. First, the type of offense which is going to be a candidate for summary trial, as our friends earlier on indicated, will be offense where the punishment is really a very light one and so on. That is one. Or where the enactment has provided that it will be tried summarily. Or where it is not indicated that it's supposed to be tried by indictment, then by default, all offenses are to be tried summarily. So the default rule is that all criminal offenses are to be tried summarily, except where it has been stipulated that in the enactment or the law creating the offense, it's been stated that that particular offense shall not be tried summarily. That would be like the only exception. Good. So what are the steps? In the summary trial, the accused person will be put before a judge sitting alone, the judge or the magistrate sitting alone by himself or herself. Now, when the case is called, the accused person will enter the door, the charges are read to him, and then he will be asked, are you guilty or not guilty? Then the accused person will have to enter his plea. If he pleads guilty, that is judicial confession to the commission of the offense. In other words, he is confessing before the court that he actually committed the offense. Now, there should be no ambiguity in the plea of guilty. So there's nothing like, I am guilty with explanation. There's nothing like that. You are either guilty or not guilty. Good. Or you may plead not guilty. If you plead not guilty, then the court will have to go through a full-scale trial to actually establish whether you are guilty or not guilty. But again, as a result of further development which we have had in our criminal procedure, and also thanks to the public interest litigation of Mr. Martin Febu, a very good friend, it has set us thinking about a lot of aspects of our criminal justice system. And we have what we call the practice direction on disclosure and case management criminal proceedings issued in 2018, which requires that where the accused person, for example, has pleaded not guilty and so on, counsel for the accused person is supposed to be given all the necessary documents, including the charge sheets, the facts, and any other document which the prosecution is going to rely on in prosecuting the accused person. Now, the accused person or his lawyer does not have to actually also exchange document at this stage. The reason being that not until a prima facie case of guilt is made against the accused person, the accused person does not bear any burden to prove his innocence. And that is why he doesn't have to exchange any document at this stage with the prosecution. It is the prosecution which is going to prosecute him. And then the law says that there should be disclosure. There should be no ambush trial. Whatever the prosecution has under its sleeve to be used against the accused person, it must actually share with the accused person or his lawyer. And all these things will be ascertained during the case management stage. Now, let's come to the trial itself. So here, the assumption is that the accused person has pleaded not guilty. A plea of not guilty is a denial of the commission of the offense. And for that matter, the presumption of innocence is fully activated in favor of the accused person. And then the prosecution bears the burden to marshal, adduce, and deploy evidence to establish the guilt of the accused person beyond reasonable doubt. So, the prosecution will call 8 witnesses, and every witness will go through what we call examination in chief, and then the cross-examination, re-examination. But thankfully, because of this witness statement, which has become part of our trial, the evidence in chief will have already been reduced into writing. So the prosecution witness will enter the box, and then the evidence is adopted, and you have it cross-examined by the accused person or the accused person's lawyer. So being cross-examined simply means that the accused person or whoever is doing the cross-examination is trying to go and challenge the truth, the veracity, or the credibility of the evidence or the person who gave the evidence. So that is the main the purpose, as it were. All witnesses for the prosecution will go through that. When the prosecution has finished its last witness, we say that the prosecution has closed its case. And at that stage, the judge will have to invite the accused person to open his defense, especially so where a prima facie case of guilt has been made. Prima facie case simply means that is to say that in the light of all that the prosecution has done, if there is no any other explanation or defense, then the court is entitled to conclude that the accused person actually committed the offense. Now, where the prosecution has actually concluded, the accused person may, for example, elect to make submission of no case instead of entering his box, entering the witness box to probably give evidence or call witnesses to give evidence to help him, disprove the case of the prosecution. Submission of no case simply means that the accused person is saying that having regard to the offense for which I'm standing trial, as well as the evidence which the prosecution has so far adduced against me, and all the cross-examination that I have done, the offense for which I'm being tried, no guilt has been established against me. And if no guilt has been established against me, I don't have to defend myself. I can only put my defense across if guilt has been established. Then in which case, I have to find out whether I have any of the permissible explanation by law regarding why I should not be held guilty, despite the fact that the evidence suggests that I'm guilty. So the accused person will be making a case of submission of no case, saying that the prosecution has failed to prove his guilt. Now then the judge will have to consider the evidence and that submission of no case and make up his mind whether the judge is persuaded as to whether a case has actually been made against the accused person, in which case the judge will order the accused to open his defense, or vice versa. So let's assume that the judge rejected the submission of no case and concluded that there's a case for the accused person to answer. The accused person may choose to either give evidence himself or just call witnesses to give evidence. And they all go through the same procedure of giving evidence in chief, and then being cross-examined and then re-examined. When he has exhausted all his witnesses, then we have what they call the address stage. The court will then ask the prosecution and the accused person or their lawyers to actually address the court on the evidence adduced before the court and the relevant law in relation to the offense for which the accused person is being tried. Then the court will adjourn to give its decision, its judgment. And the decision will be to say that the accused person is guilty, and for that matter, he is convicted and is going to be sentenced. So if the accused person is found guilty, the next thing is that you are convicted, and for that matter, you are going to be sentenced. Sentence means that you are going to have the prescribed punishment meted out to you. And then we also have the other verdict, where the judge will say that the accused person is not guilty, and for that matter, the accused person is acquitted. And when you are acquitted, the next thing is that you are discharged. Discharged means that you are released from the proceedings and from any detention and so on. So in a nutshell, that is summary trial. Before we go on to trial and indictment, my panelists, any brief addition?
Hello, Doc. Yes. Please, I wanted to add that on the plea, the accused can also refuse to plead. And in that instance, under Section 171 of the Criminal Procedure Act, then the judge is to enter a plea of not guilty. And the reasons why an accused can refuse to take a plea may include the fact that he has already been charged on that particular fact, or that the court in which he is placed before does not have the jurisdiction.
Okay. All right, thank you, Ajua. Any other? Okay, so now we address the last leg, and then we will draw the curtain down on this session. And maybe later on in the night, we'll do some landlord discussion. Good. So trial on indictment. Trial indictment, as indicated, trial indictment is an elaborate trial. Please, can you mute yourself? It's an elaborate trial procedure, and for that matter, reserved for very serious offenses with the serious punishment accompanying it. So all first-degree felony offenses, as we were told earlier on, are trial and indictments, and they may either carry a death sentence or a life sentence, as it were. And as we've also noted, the Attorney General can decide that any offense which is not ordinarily tried on indictment can be tried on indictment, depending upon the exigencies of justice or the need to serve the ends of justice. Now, for trial indictment, as we have indicated, 2 stages. The first stage, we have the committal proceedings, and committal proceedings actually takes place in the district court. Let us keep that in mind. And what is the point of the committal proceedings? That is a preliminary hearing. So the preliminary hearing, which is the committal proceeding, actually involve the court finding out whether the prosecution has provided the bail of indictment and summary of evidence. So the bail of indictment is the document which states in writing the charge against the accused. You know, like the particular charge the accused is being is going to be tried. So the offense and then the essential facts satisfying the requirement of that offense. That will be like the charge, and that is like the bail of indictment. And then a summary of evidence. A summary of evidence is supposed to be a list of witnesses and a brief statement of the evidence which each of the witnesses, for example, is going to give, as well as any supporting documents which may be tendered during the trial in support of the prosecution case against the accused. So all those things constitute what we call the summary of evidence. So during the summary, during the committal proceedings in the district courts, the prosecution will address the courts and then try to explain the case against the accused. The accused person may also choose to make a statement, and then the prosecution is supposed to actually show that all the basic requirements of the particular offense, let's say that are present in the bill of indictment and also the summary of evidence. Now, at the end of it, then the court will have to satisfy itself as whether there is enough, material which can support, let's say, a prima facie case as far as that offense is concerned against the accused person. Now, a prima facie case here is used in a very cautious sense because we are just assuming that now that we have this list of witnesses, the summary of the evidence and any supporting documents, assuming that the accused person does not have any answer, any rebuttal to any of this, can these on their own support the charge for which the accused person is going to be tried? So that is what the district magistrate is supposed to establish at this stage. So let us keep that in mind. So let's assume that the district court has actually come to conclusion that there is a case for the accused person to actually answer, or the prosecution be able to build a case against the accused person. So let him go to the high court to be tried. Now, at the high court, the accused person will have to, his plea will be taken. His plea will be taken, and the plea is very similar to what was touched on when we were discussing the summary trial. So the plea will be either guilty or not guilty, but for trial indictment, almost all the time, the court will enter not guilty because of the severity of the consequences and all that. Or a plea in bar here, referring to maybe autrefoi acquis or autrefoi convey. That is to say that when you are asked to play, you may say that you have been charged and tried previously in respect of the same offense or set of facts and so on. And for that matter, you cannot be tried again. Otherwise, the constitutional principle against double jeopardy will have been breached or offended. Yeah, so that can be done by the accused person, in which case the court will have to look into it to satisfy itself. But let's assume that the court is going to actually go on the trial. There'll have to be a paneling of the jury. Yes, I've seen that somebody hand this up. Yes, let's hear you. BL, let's hear you. Is it by accident? Your hand is up. Okay, Tommy.
Hello, Doc.
Mm-hmm.
Doc, good evening. And
Good evening.
my greetings to your panelists.
Good.
I want to find out, with this committal proceeding for indictable offenses, is it that committal proceedings should usually happen at the lower court? It should start from the lower court, like the circuit or district. I don't really know, but I want to know which of the lower courts should start from. Well, first, should they happen at the lower court? And if it should, which court should start the committal proceedings?
Okay, good. Committal proceedings, as you have noted, is done in the district court. The district court, yes. And then the trial proper will usually be at the high court. Good.
Oh, okay.
So now, yes, thank you. So the other thing is, how do you get the jury to help the judge to do the jury trial, since we have a trial on indictment at this stage? Now, when we say a jury trial, trial and indictment, we should remember that the trial may be with the jury or with assessors, right? But let's talk about the jury first, and then my panelists will just say a word or two about assessors, and they will be ending the class because I have another class with the regular school, which ought to have started at 6:30, so I'm behind time, so we have to be ending this. Okay, so first of all, we have to remember that any person between the age of 25 and 60 years who is resident in Ghana and can understand English is liable to serve as a juror. And we use the word liable in the sense that being recruited for a jury service is part of exercise of the state sovereignty. It's mandatory. So long as you fall within the age range, you are 25 years or not more than 60 years, you can understand English, you are resident in Ghana, you are liable to be recruited as a juror. Only few people are exempted. So if you look at section 207 of the Act 30, the list of exemption is there, including the president, vice president, speaker, and members of parliament, justices of the Superior Court of Judicature, judges of circuit court, magistrate of district courts, coroners, deputy coroners, prison officers, police officers, some healthcare professionals, and so on. And so many other people who have been exempted. So if you don't fall within the exemption list, and if you are within the prescribed age range, that is 25 to 60, and you can speak English, you reside in Ghana, you are liable to be recruited as a juror. But certain people are also disqualified. If, for example, you've been convicted of treason or felony or an offense involving dishonesty, you are disqualified from being, from being a juror, unless you have been granted amnesty or pardon. Otherwise, you are disqualified. So let us look at that. And you should also know how the jury list is prepared. So every year, between the 1st and 31st day of May, and between 1st and 30th days of November, the a list is made of all people living within a particular district and so on, or you can also apply. You don't have to wait to be invited. You can also invite yourself and say that your name should either be included or your name should be taken off the list, which have been prepared as those who are available to serve as jurors. Of course, you need to show a cause, you need to give a reason why your name should be taken off before to be taken off, or why it should be added when they are so be added. Good. So let's assume we have like the list prepared. We have a very limited time, so we are not going to go through how the list is actually prepared. But let's assume the list of jury has been prepared, and we are going to have a trial, right? So you need to form the panel of the jury. So my panelists, how many people constitute the jury for purposes of trial?
So please, there are 7 people. 7 members has to be selected from the panel to be the panel members, and they are being led by the 4-man.
They'll be led by a foreman. So the 7 include the foreman. So the foreman is like the leader or spokesperson, as it were. Okay, so let's keep that in mind. I noted that somebody hand is up, but because I'm ending this class, let me, when I'm just ending, then I will allow 1 or 2 minutes question, and then I'm just behind time for another class. So, paneling of the juror. My panelists, can you summarize how the juror is actually empaneled during the trial? How we select the 7 from the pool?
Please, they are selected. There's a box with names of people in it, and the sheriff is the one who picks the names from the box. And when they come forward, the accused person has the opportunity to challenge. So he has 2 peremptory challenges that he can make. That is challenge that there are 3, where he doesn't have to give any reason for challenging. But after that, he has to give a reason why he's challenging their being empaneled, that particular person being empaneled. And so when we get to the 7, then the jury will be charged. They will be placed, the accused person will be placed in charge of the jury after they have selected their foreman, and then the case will be heard.
Okay, thank you. Now, so let's suppose that the jury is empaneled, and then we have to do like the trial. On the trial day, the procedure is just like the summary trial in terms of prosecution having to lead evidence, calling the witness. Each witness will go through examination in chief, cross-examination, re-examination until the last witness. And then at the end, the prosecution will have closed its case. And when the prosecution has closed its case, the accused person will be called upon to open the defense. And once you call upon, the accused person can choose to make a submission of no case. And where the submission of no case is successful, then he will be acquitted and discharged. On the other hand, where it is not successful, the judge will ask him to actually set up his defense to the case, which has been made against him by the prosecution. And when those things are over, they will have to address the court, just as we saw in the case of the summary trial. And then the court will give its decision whether the accused person is guilty and for that matter convicted and is to be sentenced, or is not guilty for that matter acquitted and to be discharged. So in a nutshell, this constitutes the introduction overview of criminal procedure in Ghana, which you should remember as part of Ghana legal system. So I'll give 1 or 2 minutes for any question before I end this session because I am behind time. Thank you. Yes, if we are attaching. Okay, Azun Taba. Okay, panelists, thank you very much. We're not hearing those asking the questions, so we'll continue again.
Thank you
Yes,
very much,
please.
Doc.